In an ideal custody case, both parents are able to properly and peacefully co-parent with one another. But that is not always the case, unfortunately. In this video, we'll walk through the legal process of removing or limiting custody rights specifically from violent or abusive co-parents in California. Hi, I'm Sina Mohajer with Mohajer Law Firm. We specialize in family law, estate planning, criminal defense, and personal injury. You probably noticed that we are currently indoors and not strolling through a beautiful park like we normally do. Well, we are expecting some rain today, but regardless of rain or shine, I want to take these opportunities to provide you with information that could potentially help you in your case. So although we are not walking in a park, the information you receive is meant to be simplified as if it is a walk in the park. So if you like the contents of this video, please hit that like button and don't forget to subscribe so you're always informed of any new videos being posted. And without further ado, welcome to our series, A Walk in the Park. In this video, I want to specifically address what constitutes violence in custody cases. What are some emergency protective measures you can take? What is the long-term custody modification process? And lastly, the kinds of custody restrictions that can be ordered. So what constitutes violence in custody cases? California courts define domestic violence pretty broadly, which includes physical abuse, threats, intimidation, harassment. You got emotional manipulation, controlling behavior, and stalking. Abuse towards children or other household members is also factored in. Even if the child wasn't directly harmed, exposure to violence can affect legal and physical custody decisions under Family Code Section 3044. So a history of abuse creates a legal presumption that granting custody to the abusive parent is not in the child's best interest. So what are some emergency protective measures you can take if you find yourself in a similar situation? If there is immediate danger, you can request an emergency protective order, or EPO, from the police department, which is usually valid between 5 to 7 days. That would give you enough time to file for a temporary restraining order from the family court, whether it's a DVRO, which is a domestic violence restraining order, or a CHRO, a civil harassment restraining order. Having that EPO gives you that level of protection until you can get into court. Now, the TRO can include stay-away orders, temporary sole custody for the protective parent, supervised visitation even to the abuser, and even a move-out order to give you some peace while at home. After you have your emergency orders, how do you go about getting a more long-term custody modification? Well, in order to receive a more long-term order, you must file a request for order, or RFO for short. In your paperwork, you can request the court to modify existing orders or even make your temporary emergency orders more permanent. The court will then consider the history and pattern of abuse, the impact on the child's safety and well-being, and whether the abusive parent completed the programs that they were ordered to do. For example, anger management, parenting classes, or even individual counseling. But remember, the burden of proof falls on the abusive parent to prove to the court that custody or visitation would be safe and appropriate, not the other way around. So what kind of custody restrictions can be ordered? If the judge finds the co-parent to be a danger, custody orders can include complete removal of custody rights, supervised visitation only at a neutral center or third-party home, which the monitor can be professional or non-professional, no overnight stays, obviously, or limited contact duration, like a few hours at a time, certainly no phone video communication without court approval, and mandated completion of domestic violence programs or therapy. Now, judges have wide discretion, so the more documentation and preparation you bring, the stronger your case will be. In this video, we went over what constitutes violence in custody cases. What are some emergency protective measures you can take? What is the long-term custody modification process? And the kinds of custody restrictions that can be ordered. If you have questions about your case or find yourself in a similar situation, please feel free to call our office to schedule a consultation. I would be more than happy to sit down with you one-on-one to figure out the best strategy to take. And as I stated in the beginning, if you found the contents of this video to be helpful, please hit that like button and don't forget to subscribe so you're always informed of any new videos being posted.